Hello and welcome to the Minimum Competence episode for Monday, April 14th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Meta's monopoly trial, Trump officials gang claims without court proof, and Harvard professors suing over $9 billion in federal funding scrutiny. Let's remember, never leave that till tomorrow, which you can do today, and read today's legal news. On this day in legal history, April 14, 1775, in Philadelphia, Pennsylvania, the first American society dedicated to the abolition of slavery was organized. Known as the Society for the Relief of Free Negroes Unlawfully Held in Bondage, it marked a critical early step in the formal anti-slavery movement in the United States. Among its key founders were Benjamin Franklin and Dr. Benjamin Rush, both prominent figures of the American Enlightenment and signers of the Declaration of Independence. The society was composed primarily of Quakers, whose religious convictions aligned with the idea that slavery was morally wrong and incompatible with Christian values. While its initial activities were limited, the group laid the groundwork for more organized and effective abolitionist efforts in the decades to come. In 1787, after the American Revolution, the society was reconstructed as the Pennsylvania Society for Promoting the Abolition of Slavery, with Franklin serving as its president. This reorganization gave the movement greater political clout and visibility. The society pushed for gradual emancipation, legal reforms, and the education and employment of freed black individuals. Franklin's involvement lent substantial legitimacy to the cause, especially when he submitted a petition to the First Congress in 1790 calling for the federal government to take action against slavery. Although the petition was ultimately rejected, it sparked the first significant congressional debate over slavery in U.S. history. The 1775 founding of the original society represents a rare pre-revolutionary acknowledgement of slavery's moral contradictions within the new American experiment. It also helped forge an early link between legal reform and moral advocacy, a tradition that would define much of the abolitionist movement of the 19th century. Meta Platforms, the parent company of Facebook, is set to face trial in Washington over allegations that it created an illegal monopoly by acquiring Instagram and WhatsApp. The Federal Trade Commission, or FTC, argues that these billion-dollar acquisitions were designed to eliminate emerging competition and solidify Facebook's dominance in the social media space. Filed in 2020, the case seeks to force Meta to sell off Instagram and WhatsApp, a move that would significantly impact the company's business, especially since Instagram alone is estimated to account for over half of its U.S. ad revenue. Meta's legal team has pushed back, calling the case weak and politically motivated. CEO Mark Zuckerberg is expected to testify, facing scrutiny over past emails where he framed the Instagram acquisition as a defensive move against competition. Meta argues that the market has since changed, with strong competition from TikTok, YouTube, and Apple's messaging services. The FTC claims Meta still dominates platforms for sharing content among friends and family, while alternatives like Snapchat and MeWe lack sufficient market presence. U.S. District Judge James Boasberg has allowed the case to proceed, but acknowledged the FTC faces a tough road. The trial will run through July, and if the FTC prevails, a second trial will determine remedies like a forced breakup. The case is one of several targeting alleged monopolistic practices by major tech firms, including Google, Amazon, and Apple. The Trump administration has repeatedly accused immigrants of serious criminal ties, such as gang leadership or terrorism, without backing those claims with evidence in court, presumably because they aren't interested in immediately perjuring themselves. One high-profile example involved the FBI's arrest of a Salvadoran man in Virginia, publicly labeled as a top MS-13 leader and terrorist. Yet the Justice Department dropped the sole charge, illegal gun possession, and instead moved to deport him without pursuing gang-related allegations in court. A similar case involved Kilmar Abrego Garcia, who was deported and later labeled a human trafficker, though no such charge appeared in legal filings. Officials have also deported 238 Venezuelans alleged to be part of the Tren de Aragua gang, despite some having no criminal records whatsoever. Homeland Security Secretary Christine Noem defended their imprisonment, citing national security while declining to present supporting evidence. Legal experts caution that making unsupported public accusations risks undermining prosecutions and due process, as it can taint juries and violate Justice Department policy. Some judges have pushed back. U.S. District Judge Paula Zinas emphasized that serious accusations should be vetted through the legal system, not just made in press conferences. Meanwhile, other alleged MS-13 members were charged through traditional indictments, showing the DOJ still uses evidence-backed prosecutions in some cases. Critics say the administration's approach mixes law enforcement with political messaging, leveraging public fear to justify aggressive immigration actions. A group of Harvard University professors has filed a lawsuit to stop the Trump administration from reviewing nearly $9 billion in federal grants and contracts awarded to the university. The lawsuit, brought by the Harvard chapter of the American Association of University Professors and its national organization, argues that the administration is unlawfully targeting the school to suppress free speech and academic freedom. The review was announced amid ongoing scrutiny of elite universities over pro-Palestinian protests, diversity programs, and transgender policies. Federal agencies, including the Departments of Education and Health and Human Services, along with the General Services Administration, began investigating $255.6 million in contracts and $8.7 billion in multi-year grants. They demanded Harvard meet conditions to continue receiving funds, such as banning protester mask wearing, eliminating DEI programs, cooperating with law enforcement, and revising departments allegedly involved in anti-Semitic harassment. The administration has cited Title VI of the Civil Rights Act of 1964, which prohibits discrimination at federally funded institutions as its legal basis. However, the plaintiffs argue that the government has not followed the proper legal process and is instead using funding threats to impose political viewpoints. Harvard law professor Andrew Crespo said the government cannot silence speech it disagrees with through funding leverage. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcast. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, it is the first responsibility of every citizen to question authority.